Good evening, everybody. My name is Wayne Ranney, and it's my privilege to serve on the board of the Grand Canyon Historical Society. And tonight we have the pleasure, with our June virtual outing, of listening to Dr. William C. Holley. And tonight we're going to be talking about From Marble Canyon to the San Francisco Peaks, Native Americans' Cultures and Rights. The mission of the Historical Society is to celebrate and promote the study and preservation of the Grand Canyon region's cultural and natural history for the education and enjoyment of our members and the public. And we are an official National Park Service partner at Grand Canyon for interpretation and education services. If you are not a member, we encourage you to become a member. Our dues are only $35 a year. We are an all volunteer organization, and it is the efforts of our members and volunteers that make these possible. Our website is very easy to access, simply grandcanyonhistory.org, and you can click on that to join or donate. I don't want to take up too much time from Dr. Holley, but we're very pleased to have him. He's a historian and postdoctoral student of the American West, 20th century U.S. history, cultural history, and indigenous history. Dr. Holley received his PhD from ASU in 2023 and was an assistant professor at West Virginia University and is currently a postdoctoral fellow in history at the University of Idaho. A manuscript titled The Mountain is Part of Us: Tourism and the American Indian Sacred Land in Northern Arizona is under contract to be published soon by the University of New Mexico Press in their Histories of the North American West series. The project examines conflicts surrounding the peaks during the period 1969 to 1984 and the rise of indigenous legal actions aimed at stopping the expansion of certain tourist activities at these sites. It's my distinct pleasure now to have Dr. Holley give us his presentation. Thank you.
As introduced, I'm going to be talking tonight about sacred sites in especially northern Arizona, a little bit southern Utah. We'll talk a little bit about that. My presentation title From Marble Canyon to San Francisco Peaks. Yeah, like Wayne said, most of my work does focus on the peaks. But one of the things I really like about being a historian, doing the research I do, doing the writing I do, is it's full of surprises. There's never a dull moment. Um, well, that's my opinion. But anyway, um, you come into a project such as this, and you think to yourself, well, I know exactly what I'm going to say, and I know what I think about it, and I think I know all there is to it. And then you start digging around and you realize you didn't know much at all, actually. And one of my big surprise moments for the work I did for my dissertation that I'm now working on for my manuscript had to do with a lot of this indigenous action that we're going to be talking about tonight. That happened about the peaks. Started actually at the Grand Canyon, specifically with Marble Canyon, and we'll talk about that here in a moment. But it also happened at the same time as another site, and this is where we get to southern Utah. You see it on the upper left here of the PowerPoint, and that's Rainbow Bridge. And so it was very interesting. There was all these different little things being woven through the work I was doing, made it a little difficult at times to keep on track because all of it was very interesting to me. I want to write about all of it. And I'd love to talk about all of it tonight. But even though I was told earlier I have until 2027 for a time limit, I don't want to keep everybody here too late. So I'm going to focus mainly on the peaks, but I am going to bring in a little bit about Rainbow Bridge. And of course, I'm going to talk about the Grand Canyon as well. Now, before we do any of that, I need to talk about DNA Legal Services. I'm not going to try and pronounce the Navajo name. I took a little bit of Navajo once upon a time, and it didn't stick well with me, and it would be a disservice if I tried to pronounce it now. So I'm just going to go DNA Legal Services. The Navajo roughly translates to services for the benefit of the people, though. DNA Legal Services was a group founded on the Navajo Nation As part of Lyndon B. Johnson's Great Society programs in 1965-66. One of those programs was the Office of Economic Opportunity, which set up grants and different funding for all kinds of projects across the United States. And part of this whole Great Society idea was that these projects that are going to help people should be in the community. And the Office of Economic Opportunity helped with that. So DNA, being a initially a Navajo legal aid service, did start on the Navajo Nation. Why was this needed, though? That's the question. First of all, you have increased connections to border towns, Flagstaff, Winslow, Holbrook, Farmington, Gallup. Any of us who've been in northern Arizona around the Navajo Nation, we're familiar with these border towns. Roads were getting better. Members of the Navajo Nation and the Hopi tribe, they were starting to come into town, do more shopping, uh, spend more time there, and increasingly moving there, especially post World War II. And they started finding that the Navajo Nation government, tribal government, started finding there was a need for legal representation for their members on and off reservation. So this didn't just apply to if you had issues in a border town with a pawnbroker and you were not getting the money you felt you were owed, or a bad car loan, or legal issues, criminal legal issues, for example. This also applied on reservation, and we're talking about federal issues such as education, welfare, land rights, and there was no legal representation for these folks. The Navajo tribal government decided it would be best if they could start up a service that is going to help their members. And this picture you see here, this is a man named Peterson Zaw. Peterson Zaw was very instrumental in helping to start DNA and recruiting the lawyers for DNA. Now, as you can imagine, in the 1960s, there were not too many Dene or Hopi lawyers. So Peterson Zaw went across the country. He recruited lawyers, young attorneys from across the nation, fresh out of law school, or doing some other legal services across with the Great Society during the 1960s. Two of these are going to be very big in my story here. We're talking about Martha Blue. At this time was Martha Ward. Her and her husband at the time, Roy, were both recruited after serving for a couple of years doing legal aid for Micronesia. Very interesting story Martha Blue told me. And then Benjamin Hufford. He was also recruited fresh out of law school. Now, these three, but particularly Martha and Benjamin, they were recruited to work at DNA's Tuba City office. Now, they did not just work at this office. They lived in Tuba City. They lived in BIA housing. They became enmeshed in the community and part of the community. And their work helped make them known in the community, not just Tuba City, but in the surrounding areas. At this time, DNA had offices in Tuba City, Window Rock, a couple other locations, I think very similar to what they have now, but there was no office in Flagstaff. There is today, but there wasn't at this time. So this is the brief history, very brief history of DNA. Now, this is important so you understand when I bring this in, what their role is in this whole story and what the role is for Martha and Benjamin. Okay. Okay. Now, most of these students, as I mentioned, they weren't native, had little to no knowledge of the Dene, the Navajo Nation, the Hopi. A lot of them were idealistic. We're talking the late 60s, early 70s, coming fresh out of law school, change the world vibes, right? That kind of a thing. And these are the people that Peterson Zaw wanted. Martha Blue, Benjamin Hufford, they fit that bill. Martha Blue and Benjamin Hufford Benjamin Hufford both started working in Tuba City in 1971. Martha Blue's main role was in education law, but she also did a little bit of welfare law, and she got involved in some land rights issues, specifically with the Peshlakai family around Wapatki National Monument. Benjamin Hufford, also largely education law. Martha's husband, Roy, did criminal law. Now, 1971 is a pivotal year in this story. Back up a little bit first. In December 1969, a Flagstaff native uh, lived in Phoenix most of the time by this time. His name was Bruce Ledbetter. He formed a company called Summit Properties. Now, Bruce Ledbetter was a real estate man. He got his feet wet in the early 60s down in Phoenix. He actually helped Lucille Ball find property in the Sedona area. And she looked at properties around Flagstaff as well. But what he really got started in the late 1960s, he worked for a corporation out of Dallas called the Post Corp. And Post was big in tourism villages. All right, so Acapulco, they had a community down in Acapulco. But in the late 60s, they got involved in the ski industry in Colorado, helping to build Buttermilk ski area near Aspen. Bruce Ledbetter, again, being from Flagstaff, he knew the area well. Late 1960s, if you're familiar with Flagstaff weather history, was really, really good for skiing. We cannot say that all the time for the snowball, either modern day or previously. In fact, one of the main owners of the snowball for most of its history up until the 1970s made quite a tidy profit for himself by buying the resort in after bad ski seasons and then selling it after good ski seasons. Well, the winter of 67, 68 was a fantastic season for Flagstaff. Winter of the century, storm of the century they had. And the owner at the time was able to make quite a tidy profit of it. One of my favorite stories of this time in 1968, the winter of 1968, is Senator Robert F. Kennedy was campaigning to be president in 1968. And at a campaign stop in Arizona, his wife was an avid skier and she skied the Snow Bowl. And the Arizona Daily Sun quoted her as saying that it had the best snow of any ski area she's been to, better than Aspen, better than Vail. So, late 1960s, real estate developers, people who were involved in the tourism industry, not just around Flagstaff, but regionally as well, started seeing some dollar signs in their eyes when they were thinking about the Arizona Snow Bowl and Flagstaff in general. Bruce Ledbetter, though, had a benefit. He owned property at the base of the mountains. The square, kind of, well, not square, but the shape you see here on this aerial view here, it represents Summit Properties and Bruce Ledbetter's holdings of about 320 acres in Hart Prairie, which again, this is at the base of the mountain of the San Francisco Peaks near the Arizona Snow Bowl. This is private land at the time. All right, this is what they call an inholding. It's surrounded by U.S. Forest Service land and other private land. Now, Ledbetter wanted to take the 320 acres and he wanted to develop something like Buttermilk or Vale, these projects that he had worked on or that he had seen worked on, a resort community for year-round living, but also second homeowners or people who just want to do timeshares. Condos were a big part of this. The problem is, as you can see on this map, if you look closely here at right after under Agassiz Peak, you can see some lines coming down. That's the Snow Bowl. He's not connected. Now, Bruce Ledbetter had no problem getting the county, Coconino County Planning and Zoning Board, and the Board of Supervisors to approve his plans to build this resort community. But in order to get to the Snow Bowl, which was on Forest Service land, he had to build a tramway. Now, December 69, this is when he proposed it. On January 1st, 1970, President Richard M. Nixon signed into law the National Environmental Protection Act, which changed the game for a lot of development in the national parks, Forest Service, any federal land. To build this tramway to the Snow Bowl, Bruce Ledbetter was going to have to get Forest Service approval. In addition to that, because of NEPA, he also had to have public hearings. That means the community gets to send in their comments, have public meetings where they get to say what they feel about it. Okay. At the same time, so many things going on here. So bear with me. At the same time, Northern Arizona University was interested in building a new observatory on the top of Agassiz Peak, using existing trails and building a little road to get up there. Again, this was going to have to go through a Forest Service approval process. How does this play in with DNA? How does this play with the Grand Canyon? Well, we're going to find out now. And we're going to start with a man named William Bill Beaver. Bill Beaver. Bill Beaver was the owner of the Sacred Mountain Trading Post. Still there. It's not open anymore. You can see the remains of it on Highway 89, just south of the entrance to Apatki National Monument. Bill Beaver was married to a Dene woman named Dottie or Dolly. The sources say both. She was a weaver. Bill Beaver had come to the Southwest. He got his anthropology degree at the University of New Mexico. He'd come to Flagstaff working for Museum of Northern Arizona, helping them find artists to display their wares at the annual show they had, and they still have there at the Museum of Northern Arizona. Interesting guy. He did a lot of stuff, but he was also an advocate for Indigenous people's rights. And Bill Beaver did two things in the spring of 1971 when finding out about not only the telescope, but also Hart Prairie and activity at the Grand Canyon. First, Bill Beaver wrote letters to Senator Barry Goldwater discussing, the importance of the peaks, the sacred nature of the peaks. Why did he reach out to Barry Goldwater? Because previously, Barry Goldwater had been active in getting Congress to pass a law returning the sacred Blue Lake back to the Taos Pueblo in New Mexico in late 1969. So basically, Beaver's letters amounted to, well, you said this, but now you're doing this with the peaks. At the time, Senator Goldwater deflected, said, well, no, this is a local issue. We're not going to get into this right now. But the other thing is Bill Beaver contacted Benjamin Hufford and Martha Blue at DNA. And he said, look, this is what's going on. We're having this issue at the peaks, but also the Grand Canyon National Park is looking to expand into Marble Canyon and take land that is owned or settled by Navajo farmers without consultation. Said, look, we could use some help. They have these public hearings now. Could we help? Could we get some help organizing and making sure that we have legal rights and legal aid on hand? Hufford and Ward were all in. The first hearings actually didn't start with the San Francisco Peaks. Our first hearings come with the Grand Canyon, and this was in May of 1971. Hufford, Ward, Beaver, they organized quite a contingency of both Navajo and Hopi to the Grand Canyon, the South Rim, where a hearing was held on a matter of expansion. Now, the interesting thing about the Grand Canyon expansion here in 1971, and this is where we also get representation from the Havasupai and the Wallapai, which makes sense, talking about what expansion, what proposed dams would do to their communities as well. I'm kind of going to gloss over this because not much happens for about 4 years with the Grand Canyon. And I'm going to be honest with my research, it kind of loses the thread of that. The main reason I bring this up is because it showed DNA, it showed Bill Beaver, it showed members of the Navajo and Hopi tribes that they could organize and get their voices heard, and that things weren't just going to have to happen to them anymore. They had agency in this. And they put this to use when discussing issues with the Snowbowl and Snowbowl expansion and the Snowbowl Village project proposed by Bruce Ledbetter. Ben Hufford recalled after the Grand Canyon hearings, he said, quote, the word had gotten out and people were coming into the office telling us this is important. We need to do something about this. And so our DNA's role really was just trying to help organize people and allow them to speak for themselves, which they did. By fall of 1971, a coalition of Hopi and Navajo peoples and their allies were prepared to go to Flagstaff to speak at a Forest Service public hearing that was held on October 9th. Now, there are two real items of significance to note about this hearing, okay? First, this becomes the first public instance. Now, I'm sure off record, private conversations, discussions with Ben Hufford, Martha Blue, Bill Beaver, there were Navajo and Hopi members who said, no, we don't want this. But this is the first public instance in the historical record that I have found where members of the Navajo and Hopi nations were able to communicate their beliefs about the peaks and how they felt about development on them. You see this photo here. This comes from the Daily Sun. Caption there: Hopis call for peaks preservation. Through interpreters, Hopi elders especially, quote, reminded listeners that the peaks were considered sacred by their tribes long before white men came to this area and are still considered so. One Hopi elder, he was disturbed with the fact that the mountains had already been desecrated by the ski area, the Snowbowl opening in 1937, with no thought of consulting Hopi leaders. Now, the other thing is, second, it was at this hearing where the first public calls for native co-management of the peaks was made. Up to this point, it was just assumed the Forest Service managed the peaks, and that's just how it was. Now, the sources are a bit murky about who exactly said this is what needs to be done first. It is known that the Shanto chapter house had issued a statement calling for this, as did the Kaibito chapter house. In the Daily Sun, it said Bill Beaver was the one who seconded this. Bill Beaver didn't say, yes, this should be a co-management between the Forest Service, the Hopi, and the Navajo. He didn't say it, but he said he agreed with it, and that's what the Daily Sun ran with. Coconino National Forest Supervisor Don Seaman, he was quoted as saying he would consider consulting with, but not promise the inclusion on Navajos or Hopis on the management team when trying to decide whether this tramway was a good idea or not. Now, I mentioned Rainbow Bridge in this as well. I'm going to throw Rainbow Bridge in at you folks here for a minute because I have this note here. There's no hearing for Rainbow Bridge. So, what's going on there? Rainbow Bridge at this time was already a part of, it was already a national monument. The issue with Rainbow Bridge is that we had Lake Powell. And under the Colorado River Storage Project legislation that created the Glen Canyon Dam and Lake Powell, there is actual language in there that says Rainbow Bridge shall be protected and no water should be allowed to fill in under or behind Rainbow Bridge. Problem was is some of the measurements were off, and by 1970, water's starting to fill under Rainbow Bridge. Now, initially, again, it wasn't the tribal members who got this ball rolling, but it was actually environmentalists. And in 1970, an environmental group called the Friends of Earth filed suit in federal court to stop the filling of Lake Powell under Rainbow Bridge, which means stop the filling of Lake Powell. Uh, Initially, the suit really didn't see having much chance to be successful because they were having a hard time with the environmental groups. Friend of Earth is one of them. There was a couple of recreation groups that joined as uh, co-signers with the suit, and they were having a hard time establishing that harm was actually being done. And it was an interesting thing. I was actually just reading, looking over this part of my work because I was doing some editing. The federal judge that was assigned to this case was the one who said maybe you should get the tribes involved because they could prove that there is harm because this is a site sacred to them. Now, again, there's no hearing for Rainbow Bridge. This is all going to be fought out in the courts for Rainbow Bridge. Oh, I have this slide right here. And in 1972, as I mentioned, Judge Ritter said maybe the tribe should be involved. And in 1972, a medicine man named Lamar Badoni and a few other medicine men attempted to join the suit as friends of the court, saying, hey, this is how we believe about the suit. Unfortunately, even though the judge suggested they get joined, he denied because by this point, motions for summary judgment had been made, meaning the suit's going to be wrapping up. It's too late to get involved. We can't help you here. And in February of 1972, the suit was decided against the Friends of the Earth, saying, hey, no, basically the decision was the filling of Lake Powell serves a greater need and a greater good than protecting Rainbow Bridge. That's not the end of it, though. We're going to move back to the snowball here for a minute. In May of 1972, so we had our hearing October 9, 1971. There's a lot of editorials in the Daily Sun. There's a lot of discussion, but not a lot of movement. Um, it's kind of one of the frustrating parts of my work where there's this huge chunk where I'm just basing off a lot of letters to editor Daily Sun. There's a lull in activity. May 1972, this all stops. The activity picks up major. May 20 of 1972, the Coconino County Board of Supervisors voted 2-1 to allow Bruce Ledbetter to start developing his Snowball Village. This was actually an interesting note, too. On the exact same day, May 20th, 1972, that President Richard Nixon signed an executive order returning a portion of Mount Adams, which is just a few hours to the west of me here in Washington, to the Yakima tribe. Mount Adams and San Francisco Peaks have an interesting parallel. Both of them were put into public land, namely the Forest Service, in the early 1900s without consultation from the tribes. Um, how was this rectified for the Yakima? Well, the Yakima were able to file a claim with the Indian Claims Commission. This was set up in the 1940s as a body of the federal government to provide monetary compensation to tribes for land that was wrongfully taken. The Yakima won their ICC claim, but the problem was they didn't want money, they wanted their mountain back. Now, this could only be done through executive action. So the Yakima, what they had to do is they had to appeal the ICC claim and ask for the executive branch, the president, to step in. On May 20, 1972, President Richard Nixon signed an executive order where he said, "We are righting this wrong. This mountain belongs to the Yakima, and so it shall be." Unfortunately for the peaks, there was no executive order coming. So the Coconino County approved the Snowball Village. On May 25th, 1972, that's when the Rainbow Bridge suit was decided, or that was when Bedoni decided to get in the Rainbow Bridge suit, excuse me. Summer of 1972, then, lawsuits were filed to stop the Snowball Village from becoming a reality. And there's two different lawsuits. One is DNA filed lawsuits on behalf of Navajo and Hopi elders, specifically Frank Goldtooth Sr. The lawsuit is called Goldtooth versus Coconino County. But a landowner, remember I told you about these in holdings and that Summit Properties had neighbors in that in holding. A lawsuit was filed by a landowner named Richard Wilson and his wife Jean Wilson, and they owned land right next to Summit Properties and Bruce Ledbetter. Their land was used. They had a cabin. They'd come up from the summer. Dr. Wilson, he was a geologist at the University of Arizona. The land was actually he got it through his uncle, who Coulter, who was the founder of Museum of Northern Arizona. So he'd had it in his family, and he also ran a summer camp on it. And his argument was, hey, you can't build this huge village here because this infringes on our rights for peace, quiet, and using the land how we want it. Now, these two lawsuits were both filed in the summer of 1972. Uh, for the most part, they're the same, except the DNA suit, the Goldtooth suit, added additional counts. These counts had to do with a lot of how the public notice was actually done, okay, and religious beliefs. So both suits argued that the constitutional right to due process of law, equal protection of law, was violated due to insufficient and untimely notice of public hearings. But the Goldtooth complaint added these additional claims that specifically focused on their status as Native parties and Indigenous nations. And access to land and the freedom to practice religious beliefs was at the heart of the final arguments made in the Goldtooth suit, excuse me. Plaintiffs reminded the court that the peaks were sacred to the tribes and that development impeded tribal abilities to access shrines and other sites on the peaks that were essential to their religious practices and way of life. To further this point, Frank Goldtooth in deposition described the entire peaks as, quote, a prayer, my whole medicine. He said if the peaks were destroyed, he could not be a medicine man. I cannot heal. So in this way, rather than focusing on specific sites to be saved, that summit could argue we're outside their planning area. Oh, what? We're just doing this one tramway. Your sites aren't even in our planning area. The plaintiffs, especially Goldtooth, attempted to make the board of supervisors see it's the whole mountain, not just the mountain, the foot of the mountain. And a lot of the depositions, a lot of the things I've read, it's described almost as a human being. You wouldn't cut off the toes of a human. Well, Hart Prairie is the toes of the mountain, that kind of a thing. Um, So, in this way, the attempt was to say any development on the peak. So, this was Snowball Village, this was the tramway, this was the proposed NAU observatory, this was any development at all would be a violation of the Establishment Clause of the First Amendment of the American Constitution. Now, because the two suits were so similar, they were consolidated into one suit in the fall of 1972, and they were actually moved out of Coconino County Superior Court. They got a change of venue and down to Maricopa County. So, although Summit's going to fight, some attention was paid to Wilson's complaints. The legal team put more emphasis on dismissing the case based on the counts included in Goldtooth. Summit claimed first that no Navajo or Hopi claims should be allowed to be heard because they had no standing to bring their case to court. What does this mean? Summit's relying on fee ownership of the land here. And they're saying that neither Goldtooth or Numhina or any other defendants representing on the behalf of the Navajo Nation, the Hopi tribe, none of these entities own land here, so they have no standing. Additionally, they argued because Goldtooth lived in Tuba City, I believe Numhina did as well. They're living in Tuba City, which is in Coconino County, but they don't live around the peaks. So again, they have no standing. They didn't own land in the vicinity of the Hart Prairie. They lived too far away. Summit also denied plaintiffs' claims to protection under the Establishment Clause, saying they did not argue about the nature of the peaks to Navajo or Hopi or whether they were sacred, but rather they appeared to rely exactly on that sacred nature to defend against the First Amendment claims. How are they doing this? They argued the First Amendment protects against government action and cannot be extended to private action. What does this mean? So they're saying, yeah, sure, privately, it's sacred land, but you can't say the government can not do anything because this is the government. They're not saying the government is not saying it's sacred. So as long as the government says we're fine, it doesn't matter. In response, Hufford and Ward reiterated information provided by Goldtooth, Singer, Numhina, their clients, to prove to the court that the entire area was sacred, not just the mountaintops, but the land surrounding it, including Hart Prairie. They acknowledged there's no fee ownership of the land, but they argued that ownership was assumed, quote, in a more basic and profound way because of the sacred nature of the peaks. Further, Ward and Hufford argued the First Amendment did apply due to the Indian Civil Rights Act of 1968, which established constitutional rights of self-governing Indian nations, including their own establishment clause, such as that found in the First Amendment. As you can imagine, this case wasn't just decided like that. After over a year of movement through the court systems, on October 26, 1973, Judge Howard Thompson ruled against Summit Properties. But this ruling's on a technicality. The technicality, the original zoning that was applied for in December 1969 was not the same zoning that was approved by the county in 1972. Basically, in the 2.5 years intervening between December 1969 and May of 72, Summit had changed some of their zoning, uh, changing some of the single residential houses to more condos, changing some of the commercial districts. So what the judge is saying is the county should have ruled on the original zoning and they erred in ruling on the new zoning. So the ruling did stop Summit. They said, you got to stop. But it didn't stop them permanently. All the judge said was Summit had to reapply for the zoning they were wrongly awarded in 1972. Further, Thompson agreed with Summit Properties that Indigenous plaintiffs had no standing to bring suit and dismissed all their claims. The Daily Sun, longtime supporter of the Snowball Village, did further injustice, though, when describing this in the paper by reporting that Judge Thompson said, quote, the Indians can't sue because they don't understand the legal proceedings involved. I've read the case files. Judge Thompson said no such thing. By December 1973, though, it was really clear that neither of the parties felt they gained victory with this ruling. Appeals were filed by Summit in hopes they could avoid refiling, and DNA filed appeals arguing Indigenous plaintiffs did indeed have standing to bring suit and their claims should be heard. Now, the interesting thing about this, this is a 50 years, we're talking over 50 years of conflict now over this mountain between Native peoples, between developers, tourism. This is still the only suit, the only time ever in which ski developers on or near the peaks will say, no, you can't do it. Granted, it was on a technicality, but it was the only first and only time that the court said you cannot move forward with this. This is short-lived, unfortunately. In the long history, the October 1973 ruling and an amended appeal ruling from January 1974 just basically returned Hart Prairie to the exact same place it was in 1970 and 1971. Summit Properties was free to reapply for their preferred zoning. The Wilsons needed to argue against Summit in front of the Planning and Zoning Commission and County Board of Supervisors, so more public hearings. And they would have to hope they could stop the development of Snowball Village. Finally, Indigenous peoples were once again told they had no business standing in the way of development of lands they held sacred. So after almost 3 years of conflict, we're just all back at square one. However, it only kind of appears this way. In 1970, when Summit Properties was really getting started, they faced little to no opposition. The first opposition they faced at all was in August 1970 at a planning and zoning meeting when a local landowner, Francis McAllister, voiced concerns about water. Is there going to be enough water for this project? Because part of the project was making snow, drilling wells into the peaks to get water to make snow, and also a large lake in the Snowball Village. So there was concerns about this. Is there enough water? By 1973, 1974, though, They faced a lot of opposition. And I'm not just talking about indigenous parties or Richard and Gene Wilson. This had become big news in the community. Flagstaff was a small town at this time, I think about 25,000 people. So this was the talk of the town. People knew about it and people took sides. What else, though? What's going on? So I mentioned Rainbow Bridge, the Friends of the Earth suit. That was decided against the plaintiffs. However, 1974, again, the Navajo medicine man request to join the case was denied, so they decided to file their own lawsuit. This led to another federal lawsuit titled Bedoni v. Higginson, named after Lamar Bedoni, the main Navajo medicine man in the case, against the Department of Interior Director Higginson. Now, this suit's going to go on for a long time, all the way up until 1980. I'm going to get to the end of that here in a moment. But initially in 1974, it was denied. The judge hearing it, different judge said you can't sue again, based on the idea that the greater good relied on Lake Powell and it would do more damage to stop the filling of Lake Powell than it would for Rainbow Bridge to have water underneath it. All right. This was appealed. Federal suit is going to go on a long time. I talked about Marble Canyon. By this time, Marble Canyon is incorporated into Grand Canyon National Park. In 1976, the Hart Prairie controversy gets a little bit more interesting, though, because after all these public hearings, all these lawsuits, finally the Coconino County Board of Supervisors said no development at all on the peaks above 8,500 feet. So no development. We're talking no telescopes, no land, no big communities, nothing at all for 1 year. So a 1 year moratorium on development. And this was for, hopefully, the Board of Supervisors hoped that Summit Properties and Bruce Ledbetter would be able to negotiate with indigenous plaintiffs and with community members to come up with a solution that everybody could be happy with. Ledbetter's solution was, if they want to give me fair value for my land, I'll sell it and I'll be done. When that didn't happen in 1974, Bruce Ledbetter sued as well. He countersued. He sued the Board of Supervisors, the county. He sued the Tuba City School District, accusing them of conspiracy because they provided school buses to bring Navajo and Hopi tribal members to Flagstaff for public hearings. He sued the Forest Service. He sued pretty much anybody who opposed him on this, actually, saying that there was a conspiracy against him. This suit also went nowhere, just a lot of documents in the court. And by 1976, Bruce Ledbetter sold. He was done. One of the reasons he did this, as I mentioned a few minutes ago, the Daily Sun was a big supporter of Ledbetter in the Snowball Village. His uncle was Platt Klein. If you're familiar with Flagstaff history, Northern Arizona history, first of all, Platt Klein wrote really a couple of really great books on Flagstaff history. But he was also the publisher of the Daily Sun for a long time. So it makes sense the Daily Sun would, be a little bit more on Ledbetter's side. I talked to Bruce Ledbetter though. We had a nice chat, oral history interview I did with him, and he mentioned the reason he did it is because Platt Klein finally said, "Look, this is tearing the town apart. You can't do this anymore. Families are against each other, friends are against each other, and it's just getting too ugly." Ledbetter was getting nowhere. He was just incurring more debt. He was getting sued for foreclosure on not his Summit properties, but on the Snowball. I mentioned the Snowball, it's on Forest Service land, but he held the special use permit, which permitted him to also own all the improvements to the land. He bought it from the Grassmowans, who were the ones who made a nice, tidy profit selling the ski area after good years. And they still held the note on it. And through Arizona law, they could sue foreclosure on him, and they did. And finally, he said, enough is enough. While he was still trying to figure out what to do with the land, he said, I don't want to run Snowball anymore. And he sold to a couple of Flagstaff residents led by Norm Johnson and Northland Recreation. Eventually, Ledbetter worked out a land swap with the United States Forest Service and the Nature Conservancy, where he gave away his land. And the Wilsons were involved in this too, showing that they were people of their word. They weren't just trying to stop development at all. And the Wilson land is still operated by the Nature Conservancy in Hart Prairie today, actually. But here's the problem. Ledbetter's gone. He's done. Northland Recreation says we still have a problem with the ski area. It hasn't been improved enough. We need it to be bigger. And no, we don't want a large ski resort village in Hart Prairie, but we do want a few hundred extra acres on top of the mountain to have more parking, maybe doing different ski run. This brings more legal challenges, as you can imagine. People are already keyed up at this time and led again by Richard Wilson and DNA attorneys. By this time, Martha Blue was in private practice. She was done with this by now. Ben Hufford was with it for a little bit longer before he went into private practice with Martha Blue. But we have new lawsuits. Wilson v. Block, which started in 1977 and went all the way to 1983. This is a federal lawsuit, and it's all about snowball expansion. Now, why is this federal? Okay, so moving back to Hart Prairie, this was done county and ended up in Maricopa County because they weren't suing about the tramway. The Forest Service was actually really, really slow on approving or not the tramway. Again, they had to do public hearings. They had to do an environmental impact statement. They put together a land use plan. The Forest Service never got around to saying whether they wanted the tramway or not. And that's one of the reasons that Ledbetter sued the Forest Service, because he said it was a conspiracy to deprive him of his ability to use his land. When the reality was is that this was all new and the government was inefficient then, as it is a lot of times now. So it took them a lot longer to get this done. So that was the deal with the Hart Prairie. This was specifically about the Arizona snowball ski area on the slope of the San Francisco Peaks on Coconino National Forest land. So it's going to go into federal court. That's part one of that. The other part is in 1978, Congress passed a law, the American Indian Religious Freedom Act. This put all of these debates, Bodoni v. Higginson with the Rainbow Bridge. There's other similar cases at post ERFA that had to do with Devil's Tower, Bear Butte in South Dakota, Tellico Lake in Tennessee. All of a sudden, with the American Indian Religious Freedom Act, it opens the door to federal cases alleging that Native plaintiffs had their First Amendment rights violated, oftentimes some of their 14th Amendment rights as well. So this goes to federal court. Federal court's going to take a lot longer also than the Coconino County, Maricopa County Superior Court. Again, losses are incurred, appeals are made. This Wilson v. Block was appealed all the way up to the Ninth Circuit, where in 1983, the Ninth Circuit ruled against Richard Wilson and indigenous plaintiffs, saying that, again, they could not prove specifically that this little development is going to make that much of an impact on their land. The Wilsons in Hart Prairie, indigenous plaintiffs on wherever their sites were on the peaks, because again, the courts are looking at this as much like Ledbetter did. We'll protect specific areas, specific sites, but not the whole mountain. This was the same with Bodoni v. Higginson, decided also in 1980. Most of these cases I just mentioned, again, were decided against indigenous plaintiffs. Now, this is where my current manuscript project ends. But that's not where the conflict ends, and that doesn't mean that's where my research has ended. And in fact, I'm still working on a lot of research, and I say that's relative quiet after Wilson v. Block. In fact, in 1984, the very tops of the peaks were designated a wilderness area to save it from further development, the Kachina Peaks Wilderness Area. Kind of the federal government, the Forest Service saying, hey, here, this is what we're going to give to you. Hopefully everything's going to be, copacetic now. There was some debates in the 90s, especially on a pumice mine that operated on the opposite side of the peaks, the White Vulcan pumice mine. And that was eventually shut down with the help of Bruce Babbitt, Flagstaff resident, former Flagstaff resident, who was the head of the Department of Interior at the time. But again, this didn't make as much waves as Wilson v. Block, the Hart Prairie controversy. I'm not saying it wasn't important. It's actually very key. And again, that indigenous people and environmentalists were able to get something stopped that they alleged was harming this site. But it pales in comparison to what comes next. And that's our current timeline. This is our current issue. It's still going on. But in 2002, the new owners of the Arizona Snow Bowl proposed importing wastewater up a pipe from the city of Flagstaff to make snow. Why do they want to make snow? Anybody who's been in northern Arizona for any amount of time knows that some winters are great, some winters are not so great. And it's really, really hard to run a ski area when you can't rely on snow. 2002 happens to be one of the worst years in snowball history. If I don't have my notes in front of me on this one, but if I recall, it was only open for about 2 weeks for the entire ski season, and even those 2 weeks was just terrible skiing. I am personally not a skier, so I'm not sure exactly what constitutes good or bad skiing. Uh, I imagine there was a lot of rocks, but 2002, it just happened to be the perfect year for this proposal to come out because skiing was so bad, and tourism industry that revolved around skiing and that kind of helps propel Flagstaff in the winter along with NAU took a beating from it. But again, this is going to bring legal challenges. And the major case in this, and not the only one, as we'll see here in a minute, happened decided in 2008. It was Navajo Nation versus the United States Forest Service, alleging harm to a sacred site by using reclaimed and cleaned up wastewater on the mountain. All right. Uh, Snowball and the Arizona Department of Environmental Quality said this is A+ wastewater. The tribal members and environmentalists, Sierra Club said we don't care. It's still wastewater, and you're spraying it on the peaks. We don't know enough about it. First of all, it's just remove the sacred component for a minute. We don't even know enough about this that if it gets into the water table, if there's going to be problems later down the road. Much like in Wilson v. Block, the tribes had the American Indian Religious Freedom Act to try and help them. There were a few other issues or a few other federal statutes that helped as well. Of course, NEPA, which we already talked about, but also the Religious Freedom Restoration Act of 1993. The American Indian Religious Freedom Act, it was good. It was an important step, but even the authors of it admitted it was toothless. There was no power behind it. It was more symbolic than anything. Whereas the Religious Freedom Restoration Act of 1993 had a little bit more behind it. The Navajo Nation also relied on the National Historic Preservation Act. How does this come into play? Well, the peaks are considered a traditional cultural property, which those are defined by the National Historic Preservation Act. The same act that gives us our historic sites, historic buildings, things like that. If you're familiar at all with the NHPA, or even if you're not, there's a lot that goes into getting things added to the list and keeping them on the list. Very, very minimal disturbance has to be done to the structures or the landmarks. And this includes the traditional cultural properties, is what the tribes were arguing. If you do this, this puts this at risk. Again, much like Wilson v. Block, this goes all the way to the Ninth Circuit Court. The Ninth Circuit Court issued a ruling that said the area is sacred. There's no argument about that. But this is their exact wording. The sole effect of the artificial snow is on the plaintiff's subjective spiritual experience. A government action that decreases the spirituality, the fervor, or the satisfaction with which a believer practices his religion is not what Congress has labeled a substantial burden on the free exercise of religion. So again, they're saying the government, we can't guarantee necessarily that you're going to have satisfaction with how you practice your religion. And again, using more Western thinkings about sacred sites. Think of, basilicas, churches, cemeteries, for example. They're thinking of more specific sites rather than a whole mountain. Okay. Legal challenges didn't end. And 2012, another suit was filed, Save the Peaks Coalition versus U.S. Forest Service. It was almost word for word the same as the Navajo Nation 2008 suit, and the courts threw it out as calling it a gross abuse of judicial process. Basically, you're wasting our time. Federal courts weren't giving any relief, so the Hopi tribe attempted to go through the states. Okay, and they did this twice. Excuse me. One, they sued in the Arizona state courts as a public nuisance claim against the city of Flagstaff. They went around the snowball. They went right to the city of Flagstaff. You selling their wastewater is a public nuisance to everybody. This was dismissed in 2016. Again, they tried instead of the city of Flagstaff, they went with the Snowball in 2018, also dismissed by the Arizona State court system. This brings us kind of up to today with recent developments with the all three of these sites. And again, like I said, most of my research is San Francisco peaks, the Rainbow Bridge and the Grand Canyon. I feel are part of it. Um, Obviously, I haven't done as much work on them as I have the peaks. So let's start with the peaks. A couple few years ago, some devastating fires on the eastern slopes, the pipeline fire, one of those. Um, and as a result of some of those fires, there was some really bad flooding when monsoon season came around Doney Park, and then even into the Sunnyside area of Flagstaff, the eastern part of Flagstaff, and caused a lot of damage. The flooding did. And the city of Flagstaff got rightfully concerned. And so they're starting to look at, fire prevention, but also flood prevention. The article that I'm quoting here from the Arizona Daily Sun from March 11, 2023, county officials were talking damages in the billions if a larger fire occurred. And these fires that we're talking about were already pretty good size. And one of the things they were looking at doing, aside from replanting and things like that, was bringing back traditional indigenous practices, reaching out to the tribes. The peaks are sacred to 13 different nations. I mentioned the Navajo and Hopi through most of my talk because those are the two that are most involved in litigation. So they're the ones I have the sources on. Um, but yeah, a county official discussed talking to the tribes, bringing back traditional indigenous practices for managing the forests on the peaks. Because yes, we're in a mega drought in the Southwest right now, but this wasn't the first mega drought. Tree ring analysis shows this has happened previously on large scales, and apparently the county's saying, there's indigenous knowledge, traditional knowledge that could be helpful. Again, this is from the Arizona Daily Sun, March 11th, 2023 edition. In the area, we also had a new national monument uh, declared, the ancestral footprints of the Grand Canyon National Monument, which tribal co-management is a big part of this, much like Bears Ears in Utah. This goes all the way back to 1971 when Hopi elders and Navajo elders came to Flagstaff and said, let us co-manage the land with you. And it's taken all the way up until recent years for the federal government to go, hey, that's not a bad idea. You can maybe actually help us out. Grand Canyon still has threats. Just recently, the Big Canyon Dam at the confluence was discussed and it's been turned down, but people still talk about damming the canyon, despite Lake Powell. My question there: what of Lake Powell? What of uranium mining around the canyon? But yeah, what of Lake Powell? Lake Powell is inching closer and closer to Deadpool right now with this continued, 30 plus year drought we have in the Southwest. How does that impact Rainbow Bridge? Is that going to make it easier to protect Rainbow Bridge? Possibly, more than likely so. But, again, there's these issues where, well, if this dam doesn't work, is there another dam? There's still wastewater being used on the peaks. Other issues going on a couple of years ago. I don't know if you've seen these things where when you die, instead of being cremated or buried, you can be in a memorial forest where your remains kind of like go into planting trees. There's a memorial forest near the peaks, which it violates taboos about burial in the dead for some of these tribes, and so that's an issue that is still needing to be discussed. Um, with the drought, with increasing temperatures, is the snowball even going to be viable, even uh, with wastewater snow? Is this going to be a viable thing? How do we protect the land, public land? And these are all public lands. None of this is private land. How do we protect that land and make good use of it for all communities that love this land? Um, and what is the soul of this community? That's I end my dissertation with that question, and it's a question I come back to when I'm working on my book, is what makes the soul of a community? I would argue, having lived in Flagstaff, and having roots in Flagstaff, and just it's one of my favorite places in the entire world. The peaks in Flagstaff, I love it very much, and I miss it every day I'm not there. But I would argue that if you were going to define the soul of the community of Flagstaff, you can't leave out the peaks. For so long, they've been a symbol, not just a symbol, but the soul of the community. And so I leave with a question, and it's a question I grapple with often. How do we protect that soul, and how do we define that soul of the community for everybody, and make it work to the best? With that, I close, and I want to again thank everybody for showing up on the live stream and those who will watch this later. Again, thank you to the Grand Canyon Historical Society for having me. I've loved working with the GCHS for gosh, almost 5 years now. This is the second time I've presented for them. The first time was in person, and I hope to do more work with them in the future. And yeah, I hope there's some questions that I can answer.
Well, thank you, Dr. Holley. That was a trip down memory lane for me as I moved to Northern Arizona in October of 1975. And this discussion initially about the Snow Bowl Village was very, very much the talk of the town. I do want to mention to our listeners that if you do have a question for Dr. Holley, you need to be signed in to YouTube and you can submit your questions there. And then we will answer those questions. And we already have had one question come in from somebody asking if there is a list of names that indigenous groups give to the Grand Canyon in their own languages.
Yes, there is. And give me 1 second. I know it's in my dissertation, but I can tell you where I found it from as well. So let me pull that up real quick. Da, da, da. 1 second. So I mentioned there's 13. Usually that's the agreed amount. 13 tribes that consider the peaks sacred. And again, because I don't speak the languages, I'm not even going to do even going to try to name them or say what their names are. I've been told them by Navajo and Hopi people, but just this is my own how I feel about it. Um, and I'm looking here.
I do recall that the Hopi name for the Grand Canyon is Ongtupka, Ongtupka, Ongtupqa, and that means Salt Canyon. And the Hopi, of course, give the Grand Canyon that name because the Grand Canyon was a place where they went for their salt on the Hopi Salt Trail. I also saw a
Mhm.
reference that the Navajo call it Seyi, but that is the root word where we get Canyon de Chelly, and
Oh, okay.
it's just sort of an overall term in the Navajo language for where water runs out of the cliffs. Uh, there's no real other names from the Havasupai or the Wallapai specifically for the canyon that I was able to ascertain, but thank you for that question. Uh, there's another listener who actually moved to Flagstaff in 1971 or 72. And he wrote to me that he was at those meetings at Flagstaff High School
I want to
in the
talk to
early
this listener.
70s. And
I would love to talk to this listener.
okay, I can put you in touch with him. And he
Um,
actually worked on the deep water well that was drilled 3,000 feet plus, and they brought in a Texas oil well rig to drill those 3,000
yes.
feet, and they did
Yeah,
hit water below the property. So
they
thank you
did.
for that
Yes.
comment. You
Um,
have anything to
and
add to
and
that,
that was
Dr. Hall?
actually one of the. So let me address the first question. The uh, I'd have to double check the link, but the Forest Service should have on the Coconino National Forest Service page. They should have all the names of the peaks, and I also believe the USGS does as well. Um, It might even be on Wikipedia. I'd have to look. It's very possible it's on Wikipedia, quite honestly. And we're talking, so they have the names from, let me pull up this here. We've got, of course, the Navajo, the Hopi, the Apache, Acoma, Southern Paiute, Havasupai, Wallapai, Yavapai, and Zuni and Mojave. Those are the ones that I have found. Um, to the water, one of the issues, yeah, this is very condensed of what I've been doing. One of the issues, though, it's interesting. It was one of the residents. They had a cabin. They didn't have a large landholding like Ledbetter or Wilson. And this resident, her name is Donna Fosberg, and I met with Miss Fosberg. Um, and her husband and her at the time, they owned the Wiener Schnitzel, which is now, I think it's called the Dog House. It's on the corner of 66 and Schweitzer Canyon. But they had a little cabin out there. There was a bunch of little cabins out there. And one of the letters I mentioned when that quiet period where it wasn't quiet so much, but it's not super exciting. She wrote to the Daily Sun complaining about the mud and all the these large oil well drillers basically trying to find water out there. So yes, please connect me with the listener. I would love to speak with them because the more stories I can get, the better the work is.
Here's another comment that we've received fantastic research and wondering if it will be published, question mark, what form, question mark, and when will the book be published, question mark, and then thank you for your work, exclamation point.
Thank you. So yes, it will be published. It's available online. The dissertation is right now through ProQuest. Usually, you have to have an academic, subscription to it. So, like through ASU or something like that. I think you can pay. I wouldn't recommend that. So it is online, the dissertation. It is, but I am working on. So my dissertation covered only the Hart Prairie controversy, with a little tiny bit about Wilson v. Block and then the wastewater. I did a lot of research for all of it, but it was just getting too long, and eventually you want to get your degree. So I only did the Hart Prairie, where the book that I'm working on, the manuscript I'm working on, goes through Wilson v. Block and then talks briefly about the wastewater issues we're talking about now. Um, because that's just the way I wanted to do it. I'm not saying the wastewater issue isn't important, and it's something I might visit once this first book is done, because I have done some research on it, but uh, I'm not exactly 100% certain at the time. The book will be published through the University of New Mexico Press. I do not have a date yet because I'm still editing through the manuscript. I'm not even, they're not even expecting delivery until May of 2027. I'm trying to have it in October of 2027 because there's a big conference that I go to. I'm a member of the Western History Association, and we have our conference there, and my editor's going to be there. So if I can give them paper and, a manuscript to edit, all the better. No promises though, but hopefully no more than 2 years. There will be an article as well. I have an article pending in, I think it's this coming winter edition of the Journal of Arizona History that talks a bit more on DNA and Frank Goldtooth Sr., that part of my research. And again, I believe that's winter 2026. Those are usually made available online as well. Um, you know, I don't want to take away from GCHS Thunder, but you can also join the Arizona Historical Society too. I'm a member as well. And you get
No, no, you're not
free
taking
access to
away at all. I
that.
mean, we work closely with them.
Yeah. So,
We work
but
closely
yeah,
with them. We're partners.
yeah,
Well,
I
thank
I
you
kind
so
of figured.
much. Thank
Yeah.
you so much, Dr. Holley. We just have a final comment here. Fantastic and thorough dissertation work about recent litigious history of these parts in northern Arizona. And listener says that you should get a joint degree in legal history. Well, you've probably been to college enough, so I'll leave that up to you. But
Yeah, I was
fantastic
lucky. Yeah.
presentation.
Thank you. Yeah, I was lucky. My dissertation director has a PhD in history and a JD, so she was very helpful in guiding me through a lot of the legal stuff. And I was very, very blessed to have a wonderful director on my committee at that time. So, but again, thank you everybody for coming. I really appreciate it.